Ready, start. The High Court has been of the considered opinion that, under the facts of this case, the court has no option but to go by the report of the experts, and in holding so, the High Court is supported by the Delhi High Court decision in the case Jindal Steel and Power Limited and another versus Union of India and others 2023 SCC online DEL 4401, wherein it was held that the issue raised in the petition was highly technical in nature and therefore no adjudication in proceedings under Article 226 of the Constitution of India was permissible. Para. In the case Jagdish Mandal versus State of Orissa 2007 14 SCC 517, the Supreme Court has held that judicial review of administrative action has been devised to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. The Supreme Court is very clear in its mind that while exercising the power of judicial review, the constitutional courts should first pose themselves to the questions as mentioned therein. If the answers to the aforesaid questions are in the negative, there should be no interference under Article 226 of the Constitution of India. Para. The Supreme Court has observed that the tenderer or a contractor with a grievance can always seek damages in a civil court. Attempts by unsuccessful tenderers with imaginary grievances wounded pride and business rivalry to make mountains of molehills of some technical or procedural or some prejudice to self and persuade courts to interfere by exercising powers of judicial review should be resisted. Such interference, either interim or final, may hold up public works for years or delay relief or successor to thousands and millions and may increase the project cost manifold. Para. Therefore, a court, before interfering in tender or contractual matters in exercise powers of judicial review, should pose to itself following questions: 1. Whether the process adopted or decision made by the authority is malified or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably in accordance with relevant law could have reached whether the public interest is affected. Para. If the answers are in negative, there should be no interference under Article 226. Cases involving blacklisting or imposition of penal consequences on a tenderer, contractor, or distribution of state largesse, allotment of sites, shops, grant of licenses, dealerships, and franchisees stand or a different footing as they may require higher degree of fairness in action. Para. The High Court in paragraph 10 of the order of February 5, 2026 had specifically directed that the charges for initial expert evaluation shall be borne by a respondent to MSTC Limited, and that after receipt of the report from the expert body, if no fault is bound in the system of respondent to as alleged by the petitioner shall reimburse the said amount to the respondent to the expert body has now recorded a specific finding that no fault was found in the system of respondent to. Para. Accordingly, the High Court has dismissed the writ petition and summarized its order with direction to the petitioner to reimburse the respondent to the amount incurred by it for obtaining the expert report within 3 weeks from the date of receipt of the statement of expenditure. Para. Respondent to has been asked to furnish to the petitioner the statement of expenditure along with the relevant receipts within 1 week from the date of receipt of order of the High Court. At this stage, the petitioner counsel sought extension of interim relief. The prayer was strongly opposed by the lawyers representing the respondents. The High Court rejected the request, stating that considering the findings recorded in the judgment and this being a tender matter, the court was not inclined to grant the said prayer.